A bipartisan group of 35 former judges filing a striking brief calling for an investigation into that settlement that led to the creation of President Trump's $1.8 billion, what he calls the Anti-weaponization Fund. The deal was struck in exchange for Trump dropping his lawsuit against the IRS. It also grants him, his family, and businesses immunity from ongoing inquiries into their taxes. It calls the settlement a product of collusion and is itself a fraud on the court.
Hello guys, welcome. Adam is here. So what just happened, guys? Federal judges across multiple jurisdictions are issuing devastating rulings against Trump's policies, using language like fraud, collusion, and bad faith, while demanding sworn declarations from senior officials. The coordinated judicial assault goes beyond ordinary legal analysis, framing administration conduct as fundamentally unlawful and abusive. We need to talk about what's happening to Trump's legal strategy, because this is absolutely stunning and jaw-dropping, and it's all happening in real time, documented in court transcripts, captured in news reports, and witnessed by everyone who has been paying attention to the federal judiciary. When Trump returned to power, his administration was supposed to be unstoppable. They were supposed to have all the legal firepower, all the institutional advantages, all the political momentum to push through whatever policies they wanted. That was the entire narrative.
Another independent, once bipartisan federal agency created by Congress in 1914. In that law establishing the Federal Trade Commission, and again, like laws governing several other or couple dozen other federal agencies, Congress limited the president's power to remove commissioners, saying that they had to be staggered and they should be bipartisan. Today, the court said that violates the Constitution's separation of powers, that these executive agencies now have so much power that the president has to be able to say he's in charge of them, that the buck stops with the president because they're acting on his behalf, unlike when they were created 100 years ago. And that voters have to know who to hold accountable if you don't like what the FTC is doing. So that's that ruling. A win for the president. He can replace these members of these independent executive agencies like the Federal Trade Commission, the National Labor Relations Board, on, but not the Federal Reserve.
The courts would fall in line. The legal challenges would fail. The administration would prevail. But that narrative has completely collapsed. And now, in courtroom after courtroom, judge after judge is delivering rulings that go far beyond ordinary policy disagreements into territory that is constitutionally alarming. They're making specific findings about bad faith. They're documenting patterns of deception. They're characterizing executive branch conduct as fraudulent and collusive. This is what happens when you push the legal system too far and expect the courts to just go along with it. The nightmare ruling framing that we're seeing across federal courtrooms is reaching toward a pattern in which federal judges are not merely ruling against specific administration policies on technical legal grounds, but are framing the conduct underlying those policies in language that goes beyond ordinary legal analysis into the territory of documented judicial findings about bad faith, abuse of office, and what multiple sitting and retired federal judges have characterized as fraudulent conduct.
We begin with breaking news. A federal judge has temporarily blocked the Justice Department from moving forward with that so-called anti-weaponization fund. We want to get right to CBS News senior White House and political correspondent Ed O'Keefe, who joins us now. So, Ed, what are we learning about this?
Yeah, U.S. District Judge Leonie Brinkema said in a brief order that this temporary halt to the fund allows her to consider whether to grant longer-term consideration of this suit. Perhaps no surprise, because in essence, every time one of these lawsuits gets picked up by a judge, they usually slap a temporary restraining order of some kind on it. And so in this case, there is a group challenging the new fund, which of course was announced by the Justice Department earlier this month. It is being challenged by a handful of individuals, and they argue that this fund is a collusive agreement between the president and his administration. The quote has no congressional authorization, no basis in law, and no accountability.
When Judge Leonie Brinkema barred the administration from setting up the proposed $1.8 billion fund, it was not just a ruling that the fund was unauthorized. It was a judicial demand that top officials file sworn declarations confirming the fund was permanently dead. a demand that reflected the court's documented assessment that the administration's assurances could not be trusted without the specific legal consequence of sworn personal commitments from named individuals. Retired federal judges, 35 of them representing decades of combined federal judicial experience, joining legal filings attacking a Trump-backed settlement around that fund as fraudulent and collusive, is not the ordinary background noise of legal dispute about administrative policy. It is an extraordinary mobilization of the retired federal judiciary against specific conduct by the executive branch that those former judges have formally characterized in terms that carry the weight of their combined professional and institutional authority.
Federal judges from both political parties, they have joined a growing legal effort to block President Trump's anti-weaponization fund. In a motion that was filed on Wednesday, the 35 retired jurors, they asked a judge in Miami to reopen President Trump's lawsuit against the IRS. The Justice Department, they announced the creation of the nearly $1.8 billion fund as part of a settlement with Trump over that lawsuit. Well, the group of judges say that the lawsuit, quote, itself is a fraud on the court and that the settlement, quote, was not and never will be legally justified.
Federal judges who have ruled against Trump, reporting waves of threats and harassment afterward, becoming the subjects of documented harassment campaigns each time they rule against the administration, is not the ordinary political fallout from adverse court decisions. It is a specific and documented pattern of judicial intimidation that has its own legal and constitutional significance, and that reflects the specific quality of the confrontation between the courts and this specific administration. The zero path to appeal and the resignation inevitable are both overstatements of what the legal reality supports at this specific moment. But the nightmare quality of the rulings the specific language judges are using, the specific conduct they are finding to be unlawful, the specific mobilization of the former judiciary against executive branch conduct characterized as fraudulent is not an overstatement. It is the documented description of what is happening in federal courts across the country, as the judicial confrontation with the Trump second-term agenda accumulates rulings and findings and judicial statements that are more pointed, more personal, and more constitutionally alarming than anything the ordinary course of appellate policy litigation produces. To understand why the accumulated judicial rulings against the Trump second-term agenda have the specific quality the nightmare framing is reaching for, why they feel qualitatively different from ordinary policy litigation losses even when each individual ruling is technically appealable, and even when the administration continues to find legal workarounds, you have to understand what it means when federal judges move from simply finding specific policies unlawful to making specific findings about the nature and the intent of the conduct underlying those policies. A court that finds a visa fee to be an illegal tax and orders it annulled is a court doing its ordinary job of reviewing executive branch regulatory action for compliance with statutory authority. That is routine appellate administrative law. A court that bars an administration from setting up a fund it characterizes as a potential slush fund and then demands sworn declarations from named senior officials confirming the fund is permanently dead is a court that has made a specific judicial finding about the trustworthiness of the executive branch's assurances. A finding that the assurances alone are insufficient and that specific personal legal commitments from specific named individuals are required because the court's assessment of the executive branch's behavior is that it cannot take at face value the administration's statements about what it will or will not do. That specific finding, the demand for sworn declarations rather than assurances, is itself a nightmare-quality ruling in the sense that it reflects a judicial assessment of executive branch credibility that goes far beyond ordinary policy disagreement. The 35 retired federal judges who joined legal filings attacking the Trump-backed settlement as fraudulent and collusive are the specific institutional phenomenon that most directly gives the nightmare ruling framing its constitutional weight in its most alarming quality. Retired federal judges do not typically involve themselves in political litigation. They have finished their service on the bench. They have no institutional role in the ongoing cases. Their involvement in legal filings is a form of amicus participation, the submission of their collective legal judgment as former members of the judiciary that the conduct being described in the filings meets the specific legal standards they are applying to it. 35 of them characterizing the settlement as fraudulent and collusive is not ordinary legal commentary. It is the mobilization of a significant portion of the former federal judiciary, former judges who collectively represent decades of experience applying the law to specific fact patterns against specific conduct by the executive branch in terms that carry the full weight of their judicial backgrounds. The fraud and collusion characterizations are not political epithets deployed in political debate. They are specific legal conclusions drawn by former legal officers of the court about whether specific conduct meets the specific legal standards that define fraud and collusion. That is the nightmare quality the headline is reaching for. Not a single ruling eliminating every appeal, but the accumulation of judicial findings by both sitting and former judges that the conduct underlying the policies being struck down goes beyond ordinary executive overreach into territory that the legal system's most authoritative remaining voices are characterizing in some of the most serious legal terms available. The Rhode Island ruling striking down immigration rules that left many legal immigrants in indeterminate legal limbo is the specific ruling that most directly illustrates the human dimension of what the judicial nightmare is documenting. Legal immigrants placed in indeterminate legal limbo by executive action are not abstract legal constructs. They are real people, visa holders, green card applicants, long-term residents whose ability to remain in the country, to work, to keep their families together has been made uncertain by specific administrative decisions that a federal judge has now found to be unlawful. The nightmare quality of the immigration rulings is not just that they block specific administration policies. It is that they describe the human consequences of those policies in terms that make visible the specific harms that the policies were causing, harms that the administration's legal theory said were permissible and that the courts have now found were not. And the pattern of rulings across immigration, financial regulation, and other policy domains is creating an accumulated judicial record of the second-term administration's most contested policy choices being found unlawful in ways that are documented and permanent regardless of what happens on appeal. The specific phenomenon of judges receiving waves of threats and harassment after ruling against Trump is the element of the nightmare ruling story that is most directly alarming about the constitutional health of the federal judicial system, and that deserves the most serious and most specific attention. Federal judges occupy a constitutionally critical role. They are the independent arbiters of legal disputes, the officials whose institutional function depends on their ability to decide cases based on the law and the evidence rather than on political pressure or personal fear. When federal judges who rule against the administration face documented waves of threats and harassment, when the experience of ruling against the president generates specific and documented personal danger for the judges making those rulings, the independence of the judiciary from political pressure is being compromised in exactly the way that the constitutional design of life tenure and salary protection was supposed to prevent. The fact that this is happening, the documented pattern of judicial harassment campaigns, is itself a nightmare-quality development in the constitutional sense because it reflects the specific mechanism through which judicial independence can be degraded not through formal institutional changes, but through the intimidation of individual judges who are trying to do their jobs. The zero path to appeal formulation is the specific element of the headline that most significantly overstates the current legal reality, and understanding why it overstates the reality is essential for honest engagement with what the judicial rulings actually mean. Every major ruling against the Trump administration in the current period has come with some form of appeal workaround or alternative path that the administration's lawyers have identified and pursued. The Massachusetts visa fee ruling is being appealed. The Brinkema Fund ruling explicitly left the door open to modification. The immigration rulings are subject to appellate review. The zero path to appeal is the dramatic compression of a legal reality that is more accurately described as a narrowing of available paths, as a legal environment in which the administration's most aggressive policy choices are being found unlawful by multiple courts in multiple jurisdictions in ways that limit the available legal maneuvers even when they do not eliminate them entirely. That narrowing is real and consequential even when it stops short of the absolute finality that zero path to appeal would suggest. Now let us examine what the full picture of the accumulated judicial rulings, the visa fee annulment, the fund bar, the 35 retired judges' filings, the immigration rulings, the judicial harassment pattern means for the overall trajectory of the second-term Trump presidency's relationship with the federal judiciary, and why that relationship is entering a constitutional phase that has no clear precedent in the modern history of civil judicial relations. The most fundamental thing to understand about the accumulated rulings is that they are not happening in isolation. They are happening simultaneously across multiple policy domains in multiple federal judicial circuits before multiple different judges who are reaching similar conclusions about the lawfulness and the intent of specific administration policies. The Massachusetts visa fee ruling and the Brinkema Fund ruling and the Rhode Island immigration ruling are not three instances of the same political judge blocking the same administration policy. They are three independent judicial findings reached by three different judges in three different jurisdictions applying three different bodies of law, all arriving at conclusions that find specific administration conduct to be unlawful and in some cases dishonest or abusive. The accumulated quality of those findings, the pattern of independent judicial conclusions across multiple jurisdictions and multiple policy domains, is itself a form of the nightmare quality that the framing is trying to capture. No single ruling eliminates all appeal paths, but the pattern of rulings establishes a judicial record of administration conduct that is more comprehensive and more authoritative than any individual ruling could be. The Brinkema Fund ruling demand for sworn declarations from named senior officials is worth extended examination because it represents a specific form of judicial assertion of authority over executive branch conduct that is unusual and constitutionally significant. When a federal court demands that specific named government officials file sworn declarations about their intentions and their conduct, it is doing something more than issuing an injunction against a specific policy. It is making a specific assertion of judicial authority to compel executive branch officials to be personally accountable under penalty of perjury for statements about what they will and will not do. That assertion, the demand for personal sworn commitments rather than institutional policy assurances, reflects a specific judicial assessment that the institutional assurances are insufficient. It is the court saying in the most direct terms available through the judicial process that it does not trust the executive branch to comply with its rulings without the specific legal consequence of perjury exposure for the named individuals who make the commitments. That is a nightmare quality finding in the constitutional sense, not because it eliminates appeal paths, but because of what it reveals about the judicial assessment of the executive branch's relationship to the courts and to its own commitments. The 35 retired judges' characterization of the Trump-backed settlement as fraudulent and collusive deserves careful examination for what it reveals about the specific legal standards being applied and why their application by former federal judges carries the specific institutional weight that it does. Fraud in a legal context is a specific claim. It asserts that specific misrepresentations were made with specific intent to deceive to specific parties who relied on them to their detriment. Collusion is a specific claim about the coordination of conduct for improper purposes. When 35 former federal judges collectively assert that specific conduct meets those specific legal standards, they are not engaging in political rhetoric. They are making specific legal conclusions that they are professionally and personally qualified to make about specific conduct that they have reviewed and assessed against the legal standards that their careers as judges required them to apply. Their collective willingness to make those specific conclusions in formal legal filings to go on the record as former federal judicial officers asserting that specific executive branch conduct meets the legal definition of fraud and collusion is the specific accountability action that gives the nightmare framing its most directly alarming quality. 35 former federal judges cannot all be wrong, as the opinion piece headline put it, and their collective legal conclusion about the conduct they are assessing is a finding whose institutional weight is not diminished by the fact that they are retired. The judicial harassment pattern, the waves of threats that federal judges report receiving after ruling against Trump, creates a specific and deeply alarming constitutional dimension to the judicial confrontation that goes beyond the ordinary legal and political consequences of adverse rulings. The constitutional design of the federal judiciary rests on the premise that federal judges can decide cases based on the law and the evidence without fear of personal consequence for their rulings. Life tenure is not just a benefit, it is the specific constitutional mechanism through which judicial independence from political pressure is supposed to be maintained. When judges who rule against the administration face documented personal threats that require security responses and that generate specific fear for their personal safety, the specific constitutional mechanism of judicial independence through life tenure is being undermined by a form of intimidation that the constitutional design did not specifically contemplate. The harassment campaigns are not formal legal pressure. They do not change what the law says or how it applies, but they create specific environmental pressure on judicial decision-making that is incompatible with the constitutional design of an independent judiciary. And the specific pattern of those campaigns, their consistent occurrence after anti-administration rulings, communicates a specific political message to every federal judge who is considering how to rule in a case that involves the administration's interests. That message is the nightmare quality development that goes beyond any individual ruling. The pattern of legal workarounds that the administration continues to deploy after adverse rulings, the immediate signals of appeal in the visa fee case, the potential for sworn declarations to modify the Brinkema Fund ruling, the continued litigation across all the policy domains where courts have ruled against the administration, reveals a specific governing strategy that the nightmare ruling framing is responding to. The administration does not accept adverse rulings as authoritative statements of what the law requires. It treats them as obstacles in an ongoing adversarial proceeding, as setbacks that can be appealed, worked around, or replaced with alternative legal theories that achieve the same substantive policy goals through different procedural mechanisms. That approach to adverse judicial rulings is not the approach of an executive branch that treats the judiciary as the authoritative interpreter of law whose rulings define the boundaries of permissible executive action. It is the approach of an executive branch that treats judicial rulings as one factor in an ongoing struggle for power over the implementation of its preferred policies. And the specific pattern of workarounds and appeals that the administration is pursuing is itself a constitutional development, a documented pattern of treating the judiciary not as a co-equal branch whose interpretations of law are binding, but as an obstacle in a political and legal war whose terms the administration is defining for itself. The specific economic consequences of the judicial rulings that opinion pieces are now describing, the argument that Trump's court losses kill his fund plans and may threaten unrelated institutions financially, illustrate the specific way that the nightmare quality of the rulings extends beyond their immediate legal effects and into the broader economic and institutional landscape. The Brinkema Fund ruling and its implications for connected financial arrangements does not just block a specific policy. It creates specific uncertainty about the financial arrangements that were associated with that policy and about the viability of financial instruments and institutional commitments that were structured in anticipation of its implementation. That uncertainty is itself a form of the nightmare quality, the specific way that judicial findings about bad faith and fraud create ripple effects through financial markets and institutional relationships that extend far beyond the specific legal questions the rulings directly address. So what does the full picture of the accumulated nightmare rulings, the visa fee annulment, the fund bar and its demand for sworn declarations, the 35 retired judges' filings, the immigration rulings, the judicial harassment pattern, the administration's continuing workaround strategy mean for where the constitutional confrontation between the courts and the executive branch actually stands, and what realistic expectations should there be for its trajectory. The first thing to understand is that the resignation inevitable framing is not an accurate description of what the legal outcomes require. None of the rulings mandate resignation. None of them eliminate every appeal path in the way that zero path to appeal would suggest. The administration continues to find and pursue legal off-ramps in case after case. The resignation that the framer predicts is a political conclusion about where the accumulated judicial pressure is heading, not a legal description of what any specific ruling requires. Understanding that distinction is essential for honest engagement with what is actually happening and with the genuinely significant accountability developments that the more accurate framing would describe. The second thing to understand is that the genuinely significant accountability developments, the things that the nightmare ruling framing is trying to capture in its most compressed and most dramatic form, are real and consequential, even when the specific dramatic scenario of zero appeal paths and inevitable resignation overstates them. The demand for sworn declarations from senior officials is a real and significant assertion of judicial authority over executive branch conduct. The 35 retired judges' fraud and collusion characterization is a real and significant mobilization of former judicial authority against specific executive branch conduct. The harassment pattern is a real and constitutionally alarming development in the civil-judicial relationship, and the accumulated pattern of independent judicial findings across multiple jurisdictions and multiple policy domains is a real and consequential judicial record of what courts are concluding about the lawfulness and the intent of the administration's most contested policy choices. Those are the real nightmare quality developments, and they deserve the attention and the urgency that the more dramatic framing is designed to generate, even when the specific dramatic scenario overstates the immediate legal reality. The third thing to understand is the specific trajectory of the civil-judicial confrontation and what the pattern of rulings, harassment campaigns, retired judge mobilizations, and administration workarounds suggests about where the confrontation is heading. The trajectory is toward escalation. The judiciary is asserting its authority more pointedly, demanding sworn declarations, accepting retired judge briefs, characterizing executive conduct as fraudulent and collusive, making findings about executive branch trustworthiness that go beyond ordinary policy review. The administration is treating adverse rulings as obstacles rather than as authoritative legal pronouncements, appealing, working around, deploying alternative legal theories rather than adjusting its conduct to comply with judicial findings. The harassment campaigns are escalating, creating specific documented intimidation of the judicial officers most directly responsible for asserting judicial authority over executive branch conduct. Each of those trends points toward a constitutional confrontation that is deepening rather than resolving. And the specific question of whether the constitutional architecture can sustain that deepening confrontation without reaching the kind of constitutional crisis point that the framing is predicting is the live and consequential constitutional question that the nightmare rulings are raising. What the resignation inevitable framing ultimately captures about the accumulated judicial rulings is the political judgment that the legal pressure the rulings are generating is reaching a level that a presidency cannot functionally manage while simultaneously governing effectively. That judgment is the political conclusion that both Trump's critics and his political analysts are drawing from the pattern of rulings, the harassment campaigns, the retired judge mobilizations, and the continuing workaround strategy. It is not a legal prediction about what any specific ruling requires. It is a political and constitutional assessment about whether the accumulation of judicial findings characterizing administration conduct as unlawful, dishonest, fraudulent, and collusive Findings that are being made independently and simultaneously across multiple courts and multiple policy domains is creating a political and legal environment that the presidency can functionally sustain. The nightmare is the accumulation. The zero path to appeal is the compression of the accumulation's directional trajectory into a single judicial moment, and the inevitability is the political judgment about where the trajectory leads. Whether that political judgment is correct is the specific constitutional and political question that the second term's remaining duration will answer, but the accumulated record of judicial findings that has been built across the cases described in the reporting is a record whose nightmare quality is both real and documented, and whose ultimate significance for the presidency and for the rule of law is still being written one ruling at a time in courtrooms across the country. The final thing to understand about the nightmare ruling story is why it matters for the broader accountability narrative that each judicial ruling against the administration, however technically limited its specific legal effects, however readily the administration identifies appeal paths and workarounds, is being framed in the nightmare language that the headline deploys. The nightmare framing reflects the specific judgment that the accumulation of judicial findings about administration conduct is reaching the kind of constitutional saturation point at which the aggregate weight of the findings begins to matter more than the specific legal effects of any individual ruling. 35 former federal judges characterizing a settlement as fraudulent is not a single judicial ruling on a specific legal question. It is a collective judicial statement about the nature of a specific administration's relationship to the legal system that the judiciary is supposed to oversee. And that collective statement made by people whose professional lives were devoted to applying the law is the specific accountability development that the nightmare ruling framing is trying to communicate with the urgency it deserves. The rulings are real. The nightmare quality is real. The resignation and the zero appeal paths are the dramatic shorthand for a constitutional reality that is more complex and more gradual, but no less alarming for being complex and gradual. And the story it is telling about the health of the American constitutional order is one that every citizen has a stake in understanding as clearly as the available evidence supports. Make sure you're subscribed because this is going to keep developing and changing. This story is far from over. Hit that subscribe button. I'll see you next time.